Hello and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your CPD requirements, and at the end of the podcast we will explain how to get in touch if you wish to claim CPD points or if you have any comments or questions.
Hello and welcome to podcast number 65 now. Well, in this podcast we're going to look at three different cases. The first case considers whether a single employee was deemed to have transferred under TUPE. And the key question is that the EAT has to look at what constitutes an organised grouping under TUPE regulations in the context of a single employee. Secondly, we've got an EAT decision concerning disability discrimination under the Equality Act 2010. And then thirdly, there's an indirect age discrimination case and the arguments put forward by the employer to justify the discriminatory practice. And then, as a reward for staying with me to the end of the podcast, I've got a film recommendation for you. So the first case, I think is pronounced Rinda, but it might be Rynda, R-Y-N-D-A, UK Limited, and Reinsberger. So this is a Court of Appeal decision looking at the service provision change rules in TUPE, in particular in relation to the wording around an organised grouping of employees. As a quick summary, the TUPE regulations provide for the transfer of workers from an external contractor to a client, in this case, if there is an organised grouping of employees at the contractor who have, as their principal purpose, the job of carrying out activities on behalf of that client, and those activities cease to be carried out by the contractor and are brought in-house or possibly are transferred to another provider. In order for individual employees to transfer, they must be assigned to that organisational grouping. And the effect of TUPE, of course, is that the contracts of employment are transferred from the contractor to the client. It's particularly important in this case that Regulation 2.1 of TUPE expressly states that a single employee may constitute an organised grouping of employees. Well, the background facts of the case were that Ms. Reinsberger, who I'm going to call the claimant, was employed by Drivers Jonas Deloitte. Her employment started in May 2009, and her role was to manage properties mainly located in the Netherlands. During her employment, for a 4-month period, she took on some responsibility for managing properties in Germany. In respect to the Dutch properties, the claimant was still the only person who carried out that management work, and during the 4-month period, she still devoted the majority of her time to the Dutch properties. After that, she continued to work solely on the Dutch properties and was in effect a one-person department. In January 2011, there was a transfer of functions between Drivers Jonas Deloitte and Rinda UK Limited, the respondent. The respondent took over the line of work that the claimant had been doing, and the claimant moved across to Rinda. There was mention of the claimant's role being reviewed in the future, but this never materialised, so she continued to do exactly the same job as before. Well, in September 2011, the respondent dismissed the claimant, and the claimant sought to bring a claim for unfair dismissal against the respondent. Obviously, as you'll be aware, in order to bring a claim for unfair dismissal, the individual has to have 2 years qualifying service. Therefore, the claimant had to show this, that she'd got the 2 years service, and the key issue then was whether her employment had transferred from Drivers Jonas Deloitte LLP to Rinda in January 2011, under the service provision change regulations in TUPE. If she had transferred, then she would have sufficient continuity of claim to bring an unfair dismissal claim. If she did not, then her claim would fall at the first hurdle. Well, the Employment Tribunal and the EAT found the claimant had transferred under TUPE. They found that the claimant constituted a, quote, organised grouping of employees, unquote, which had as its initial principal purpose the carrying out of property management activity on behalf of the client. The fact that the claimant had carried out some responsibilities for the German properties for 4 months did not detract from their conclusion, as during that period she still devoted the majority of her time to the Dutch properties. The tribunal and the EAT held that it did not matter that the claimant's future role was going to be reviewed. The claimant in the meantime continued to do exactly the same role. Well, Rinder appealed against the EAT decision to the Court of Appeal on the basis that the claimant was not an organised grouping of employees and therefore the claimant did not satisfy the test for the service provision change under the TUPE regulations. And the argument that you might have expected to be relevant was in fact not the key point in the appeal. You might have thought that since the individual was the only person doing the role, she couldn't be an organised grouping of employees. But, of course, as I've mentioned already, TUPE regulations expressly provide that an individual can be an organised grouping on their own. So in what circumstances, and this is really where the case comes in what circumstances is an individual doing work an organised grouping? And here, Rinder, the respondent, put forward that the EAT had wrongly focused on the work which the claimant happened to be doing, which was not sufficient to meet the test for an organised grouping. Well, the Court of Appeal helpfully summarised the key case law in this area, most of which is EAT authority. The case law makes clear that in order for there to be an organised grouping, there must be some deliberate planning or intent for a single employee or a team of employees to have, as their principal purpose, the carrying out of certain work for client A. This involves a degree of conscious organisation on the part of the employer. So deliberate planning and intent, conscious organisation. The court also highlighted that the mere fact that an employee spends all of his or her time working for one client does not bring the case necessarily within the confines of TUPE. And the Court of Appeal confirmed that a single employee can constitute an organised grouping. And they gave examples in the judgment of a single cleaner provided by a cleaning firm to its client, or a single solicitor within a law firm working full-time for a particular client on a long-term basis. The Court of Appeal also gave a useful outline of the key stages to be considered when Company A takes over services that have been previously provided by Company B, and those are being provided to a common client. So Company A takes over Company B's services that are being provided to, let's say, the client. And the Court of Appeal gave some guidance on what points needed to be considered in order to determine whether there's been a service provision change within the meaning of TUPE. So, start at the beginning. You need to identify the services which the old company, Company B, was providing to the client. You then need to list the activities which the staff of Company B performed in order to provide that service or those services. Then you need to identify the employee or employees of Company B who ordinarily carried out those activities. And finally, you need to consider whether Company B organised those employees into a grouping for the purpose of carrying out the listed activities. After conducting this analysis, the Court of Appeal dismissed the respondent's appeal. It held that the claimant, although a single employee, did constitute an organised grouping within the meaning of the regulations. The fact that she had spent some part of her time managing certain properties in Germany did not affect this position. The claimant, devoted the vast majority of her time, if not all of her time, to the Dutch properties. This wasn't happenstance, but something which the employer had organised. At each stage, the employer decided the claimant should be at work managing the Dutch properties. She was not part of a team which delivered services to any other clients. It wasn't coincidence that she happened to work all the time on the Dutch properties. This was clear and deliberate planning and intent. And I think the case is a really useful one. It acts as a reminder that an individual on their own can be an organised grouping of employees, whatever the violence of the English language. That seems clear-cut. Secondly, there's obviously a slight conceptual difficulty. Assuming employees are not doing work randomly, the employer will always be organising work for the employee to do. So at first blush, it's difficult to see how happenstance might account for the fact the individual was doing the majority of their work for a particular client. Here, however, I think the facts were relatively clear. She was, in effect, a one-woman department doing distinct work. I can certainly understand the employer's argument that whilst this was the case, it was by no means certain this was going to continue. So there was an element that at this point she was doing the work, but it might not necessarily have been the situation down the road. So, happenstance. But nonetheless, the court felt that it would be appropriate to focus on the here and now, i.e. at the point at which the transfer had occurred. And equally, I think there will be cases where it's less clear-cut whether an individual is an organised grouping of one. I think the best advice for employers is to be alert to the danger that there is now the possibility, clearly, of a TUPE service provision change covering only one individual employee. After all, if there's a larger transfer which, for whatever reason, is not completely covered by TUPE, it doesn't preclude the fact that an individual might still be covered by the TUPE regulations because of the service provision change rules, and that a single person transfer can be covered. For example, we've seen transfers where there's been an employing service company, but the business that is being transferred comes out of the trading company in the group. Service provision change rules might well now be seen to assist, so that if you have stray individual employees in the service company, you may be able to transfer them over to the trading company at the same time as the sale, for example, in reliance on this case. So that's the case of Rinder UK Limited and Reinsberger. Next case, Land Registry and Houghton and others. And this is an EAT decision concerning disability-related discrimination under the Equality Act 2010. Section 15 of the Equality Act provides that an employer discriminates against a disabled employee if they treat them less favourably because of something arising as a result of their disability, and the employer cannot show that the treatment is a proportionate means of meeting a legitimate aim. It's important to note that Section 15 of the Equality Act was deliberately inserted by Parliament to move away from the need for a comparator under Section 15. As the judge in the EAT put it in this case, by using the deliciously vague, quote-unquote, formulation, quote, because of something arising in consequence of the claimant's disability, unquote, the causative link between the disability and the unfavourable treatment has been loosened. And the result of this change is it's easier for claimants to get over the hurdle of proving that there was a disability-related discrimination, and the burden of proof is then shifted to the employer to justify its conduct as a proportionate means of reaching a legitimate aim. It was accepted by the Land Registry that all of the claimants were disabled for the purposes of the Equality Act. Well, the key facts. The Land Registry operated a discretionary bonus scheme whereby all eligible employees received a bonus of £900. However, under the terms of the bonus scheme, an employee who received a formal written warning in respect of sickness absence during the year was not eligible to receive a bonus. The manager had no discretion to ignore such sickness-related warnings. This was the case despite the fact that under the terms of the bonus scheme, managers did have a discretion to ignore conduct-related warnings and could still award a bonus even though a warning had been given. Each of the claimants had had a number of sickness absence which were all attributable to their disabilities, and the Land Registry had made a number of reasonable adjustments, but despite these the claimants had received written warnings for their absence. Therefore, the claimants were not entitled to a bonus under the rules of the bonus scheme. The Employment Tribunal found that there was an issue with the bonus scheme, as it did not allow managers the discretion to determine that a written warning for sickness absence would not affect the entitlement to a bonus. It held that the non-payment of a bonus was the consequence of the claimant's disabilities, as it was their disability-related sick absence that led to them not being able to receive a bonus. Therefore, the Tribunal found the claimants had reached the Section 15 hurdle, they'd surmounted that and shown a disability-related discrimination detriment, and the burden then shifted onto the Land Registry to justify this particular policy. So, the Tribunal then went on to consider whether the Land Registry had been able to justify its actions. And it was agreed by both parties that the Land Registry had a legitimate aim, which was to operate the bonus scheme, which rewarded good performance and attendance of employees. The key question for the Tribunal was, therefore, whether the Land Registry had shown that the scheme itself was a proportionate means of meeting that aim. Well, in order to do this, the Tribunal had to balance the discriminatory effect of the non-payment to the claimants, on the one hand, with the reasonable needs of the employer to operate the bonus scheme on the other. And in conducting this balancing exercise, the Tribunal took into account, 1, that some of the claimants had improved their absence record after receiving the written warning, but this was not allowed to be taken into account under the scheme. Secondly, managers had no discretion to declare that a sick absence warning would not affect eligibility for a bonus. But, however, the managers did have such a discretion in relation to conduct-related warnings. So the outcome was that the Tribunal found the non-payment to the claimants was disproportionate and made findings for disability-related discrimination. Well, the Land Registry appealed to the EAT. The main argument put forward by the Land Registry was that the connection between the claimant's disability and non-payment of the bonus was just too remote. The reason for the non-payment was because of a prior warning for sick absence. That decision to issue the warning, well, that was a discretionary act by the manager at the time. They also argued that the real complaint was against the issuing of the warning, which would be a complaint well out of time if employees had now sought to challenge it. Finally, the Land Registry argued that the act of not allowing the claimants their bonus was an administrative act by a member of HR who had no knowledge of the claimant's disability. Well, the EAT rejected the appeal. The fact that the claimants had received a warning for their disability-related sickness, automatically disentitling them from participation in the bonus scheme, and meant that the EAT very quickly concluded that this fact was sufficient to amount to unfavourable treatment as a result of disability. Without the disability, the claimants would not have run up the level of sick absence which led to the warning, and without the warning, the bonus would not have been whether the bonus would have been paid. It was irrelevant that the claimants could have complained about the warning. That was not the issue in this case. The issue in this claim was that the claimants had not received a bonus and said they were entitled to it. The EAT also helped me clarify that it does not matter what the discriminator's motive was in acting as he did. The key question was whether the cause of the treatment was discriminatory. In this case, it was very clear that the fact of the claimant's disability-related absence led to the disqualifying warning. The motive of the HR staff member who carried out the administration of the bonus scheme was, well, irrelevant. Ultimately, the Land Registry failed to explain why there was an anomaly between the ability of the managers to use discretion in the case of conduct-related warning, but not in relation to a sickness-absence-related warning. The EAT also highlighted it as being particularly odd. The managers did not have such a discretion when the objective of the bonus scheme was apparently to award good performance and attendance, and the attendance of the claimants had improved despite the warnings. So, overall, the appeal was rejected and the award of compensation was upheld. Well, I don't think the case establishes any new principles of law, but I did want to mention it because I think it's a helpful case to illustrate practical issues. The employers may not have been aware that they would have to justify the exclusion of employees with sickness absence warnings. As such, they may never have considered whether the steps that they were taking were proportionate. I don't know. The case report doesn't make it clear. But once the Employment Tribunal had established there was a link between the individual's status as a disabled employee and the unfavourable treatment, the employer had to justify what it was doing, and it could not do this. However, I think it's also important to look at what the case did not decide. If the policy of the sickness absence warnings had been the same as the policy for any other warnings, and the manager had had a discretion as to whether or not such a warning should be given, and whether it precluded an individual from receiving a bonus, the Employment Tribunal's decision might have been very different. In other words, it's the disparity between the approach by the employer between the two types of warnings that causes the problem, not the concept by itself that an individual has received a warning for an ill health-related absence forfeits their bonus. So, the quick point in summary is to be alert, if you're acting for an employer, to the need to justify neutral rules and practices if they are applied to a protected category of individual. Conversely, if you're acting for individuals, then be alert to the opportunities offered by these and other cases. Which brings us neatly on to the third and final case, which is Braithwaite and others and HCL Insurance BPO Services Limited. So, this is an EAT decision which looks at an indirect age discrimination issue under the Equality Act. And I think it's a really good example of the uses to which discrimination law can be put by a claimant looking to challenge something that might otherwise have been thought to be relatively straightforward. So it sort of continues the theme from the last case. And the Equality Act prohibits age discrimination, whether direct or indirect. In the case of indirect age discrimination, a claimant has to prove that the employer has a provision, criterion or practice, PCP, which puts the employee at a disadvantage in comparison with others on the ground of age. For a successful claim, it's also necessary that any such PCP cannot be objectively justified by the employer. The background facts of the case are that over time, a number of employees from different companies had transferred under TUPE to HCL. The employees all transferred on their existing T's and C's and stayed there. Therefore, lots of the employees at HCL had very different terms and conditions in their employment contracts from each other. And this became a particular issue down the line when HCL was facing continuing losses and decided to address this situation by cutting costs in relation to the individuals. It did this by requiring all of the employees to agree to new terms and conditions, or otherwise they would face dismissal. And the new terms of employment didn't have, for example, benefits in relation to private health insurance, carer days, enhanced redundancy pay, reduced holiday leave, and it had increased working hours. And this put older employees at a particular disadvantage, as they were the employees who'd built up the greater entitlements under their existing contracts by virtue of their longer service. Well, the tribunal found that the requirement to enter a new contract was a PCP, but the PCP was objectively justified. Therefore, the tribunal dismissed the claim, and in finding that there was a PCP, the Employment Tribunal had decided that the requirement for all employees to agree to a new set of terms and conditions or face dismissal was a provisional practice. It held that the PCP was applied to all employees, and it found the requirement put employees within the 38 to 64 year range at a particular disadvantage when compared to younger employees. As mentioned, this was because the older employees had better contractual entitlements, so they would lose more under the new contracts, the new standard contracts. Well, the Employment Tribunal then decided the employer's PCP was justified, The employees appealed to the AT, and I'm going to focus predominantly on the question of whether or not the PCP was justified. There were other issues that were also the subject of the appeal, and indeed the employer tried to argue that there was no PCP. However, I think that the most interesting part is what the EAT said about the justification of the policy. The employer had said that the justification for the policy was not simply a desire to save costs, although saving costs was an inevitable consequence of the aim. It was a desire to ensure the viability of the business and to have market competitive and non-discriminatory terms and conditions. The case authorities in this area say that in deciding whether or not a PCP is justified, it's necessary for there to be a critical evaluation of the employer's reasons for having the PCP. If there is a disparate impact on, in this case, older employees, then there needs to be consideration as to whether the benefits of the PCP outweigh the detriment to the employees, which are being treated detriment to the individuals who are being treated adversely. Here, the employees contended that there were alternatives that they had put forward, which had not been adequately considered by the employer. Additionally, they claimed that the parent company was making significant profits, and that a significant cause of the employer's financial difficulties were the initial costs of integrating the employer with its parent company. The EAT felt the Employment Tribunal was entitled to conclude that there was a real need demonstrated by the respondent for the changes. Indeed, the monthly remuneration bill in certain months exceeded the entire income earned by the employer in that period, and there was no guarantee the parent would continue to subsidise the employer, and it had already accepted a significant amount of losses, which had to be underwritten by the parent company. The EAT accepted it was, as a minimum, a legitimate aim for a business to seek to break even year on year. Resources had to be allocated. Employees suggested that changes could be phased in or changes could have been introduced. But the EAT said the Employment Tribunal was entitled to conclude that this would delay the achievement of the legitimate aim and would have compounded the losses that the company were facing. And additionally, delaying the changes would have continued to put in place conditions which were not market competitive and which were potentially discriminatory. And the employees claimed that they could have been voluntary redundancies put in place to reduce costs. But the employer was entitled to take the view that it didn't need to reduce headcount. It needed to reduce the unit cost per employee. One of the other interesting factors used to justify these changes was that a number of the losses caused to employees were at best contingent losses, i.e. they weren't direct losses. In other words, the particular lost benefit might never have accrued to the employee. For example, unless an employee is actually made redundant, the fact that the redundancy payment scheme has been cut causes no loss to the employee. So, putting all this together, although the employees mounted a head-on attack on the justification of the PCP, the employer was able to withstand this. Employees could not come up with any better way of achieving the legitimate aims of the employer. And this is an important case. It goes into the justification arguments in a certain amount of detail. And I think the employer in this case, with all due respect, handled matters very well. There'd been an extensive consultation process. They had clearly thought about what was being proposed and were able to respond to the criticism put up by the employees. Equally, I think that employers who are looking to introduce contract changes may easily face similar claims in the future. Preparation is everything, obviously, and employers who are thinking about introducing changes could do a lot worse than read this case and the arguments put up by the employer to defend itself. Obviously, each case will be fact-specific, but a lot of the common issues will arise, as we have seen in other cases. I think then that just simply leaves the film recommendation that I was going to give you to end the podcast. And it was the film Whiplash, which I saw on Thursday. Now, obviously, in a week in which 50 Shades of Grey is released to the wider public, sending an email to your wife saying you're off to see a film called Whiplash is open to misinterpretation. But it's a fantastic film, and if you haven't seen it, I really do recommend it. Two central performances that are spectacular, and indeed one of them won Best Supporting Actor in the Oscars the other night. There is indeed an employment theme to it, I suppose you could say, whether it's ever acceptable for an employer to seek to motivate performance by employees with a bit of bullying, an awful lot of manipulation and some scare tactics all rolled into one. Why don't you see the film and see what you make of it? As I say, I thoroughly enjoyed it, and 2 hours simply flew past. So that's all for the podcast this week. Thank you very much for listening. Look forward to seeing you in 2 weeks' time, and stay safe. Thank you.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments or want to know how to claim CPD points, please email nick at nrobertson@mayorbrown.com. Our podcasts are an overview of the cases, and how the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues you are dealing with. Thanks for listening.